Today, in this video, we'll discuss about Talaq. And Talaq is a kind of divorce under Islamic law. So, exactly what is the meaning of Talaq? So, Talaq means exactly repudiation of a marriage. And that repudiation of marriage otherwise means to release or free the wife from the very bondage of marriage. So, if you go to the very definition of talaq as it was defined under section 2 subsection A of the Muslim Women's Protection of Rights and Divorce Act of 1986, it defined a Muslim woman who was married according to Muslim law and has been divorced by or has obtained divorce from her husband in accordance with Muslim law. And this definition of a divorced woman was also held in the leading case Noorjahan versus State of Maharashtra in 1995 by the Bombay High Court in its jurisdiction. So, in the very leading case, Noorjahan versus State of Maharashtra, the very definition as provided under Section 2, subsection A of the Muslim Women Protection of Rights and Divorce Act of 1986 was upheld. So, now we'll go to the very capacity, as to the capacity to divorce. So, regarding that, the male of sound mind and who was attained puberty may divorce his wife unilaterally without any cause, without assigning any reason, at his whim or capacity. And regarding that, we discussed Fatwai Alamgiri, and that Fatwai Alamgiri which explained that divorce pronounced under compulsion or in a state of intoxication or to satisfy or please or in jest by an adult and the same Muslim divorce is valid. The Hanafi laws expresses that talaq in the absence of wife, all that is necessary is the pronouncement of talaq by the husband. How he does it, when and in what manner he does it is not very material. But all the schools of law in Islam agree that talaq pronounced in delirious or in a fainting or in a sleep or in unconscious or lost in astonishment is invalid. So, these are the views of the very different schools of Sunnis and Shias as found under Islamic law in regards to capacity of a Muslim husband to divorce his wife. And the second one, that is regarding repudiation of marriage as attaining majority by the wife. So, in that connection, if the father or grandfather has acted carelessly, wickedly, fraudulently, or negligently, or to a lunatic, impotent, or to an unsound mind, or to an idiot, or unequal rank, the child or the minor has the right to repudiate the marriage on attaining majority. Under the Dissolution of Muslim Marriage Act 1939, a Muslim female can file a suit for dissolution of her marriage, but the limitations are the option must be exercised before the girl attained the age of 18 years as provided under the Act, and marriage should not be consummated. So, this is regarding how, on attaining majority, a wife or a Muslim female could repudiate her marriage on the grounds of careless marriage, or wickedly done marriage, or fraudulently, or negligently, or even to marriage to a lunatic, or impotent, or an unsound mind person, even to an idiot, or to an unequal rank. And our next was regarding the very position of whether it is of female or male. So we found that under Islamic law, the dominant position of the husband in regards to divorce. So, according to Quran, manner, maintainers of women provide maintenance and dower, and mentally and physically superior. So, all schools of Sunnis and Shias recognize this very idea that the husband as the maintainer or providing all kind of maintenance to the wife has the dominant position regarding divorce or talaq. So, our next item of discussion regarding talaq is the forms of talaq. So, what are the different forms of talaq as provided under Islamic law? So, it is either oral or written, either on the presence of two witnesses or not. The pronouncement of the words regarding talaq must be expressed, well understood, and not ambiguous, and no proof of intention is required. As to Shia law, it must be in Arabic and in a specific form in the presence of two male witnesses who must be Muslims and of approved probity. Otherwise, such persons are called adil witnesses. In case husband not knowing Arabic, the agent to pronounce the same in Arabic, and if no one is found in having knowledge in Arabic, then only it may be pronounced in any other language. So, these are the different forms of talaq as regarding to the Sunnis and Shias. So, as we have discussed regarding talaq, which is otherwise called as divorce under Islamic law, the very meaning, definition as provided under the Act under Section 2, subsection A of the Muslim Women Protection of Rights on Divorce Act 1986, and as regarding to the capacity of the male husband or attaining of majority by the wife, so also regarding the dominant position of the husband regarding divorce or talaq, and also regarding the forms of talaq. So, in our upcoming video, we would like to discuss about talaqnama and the unilateral divorce, divorce by mutual consent, and judicial divorce.